Hi friends, I am Professor Kshitij Bansal. I teach international law at Jindal Global Law School. What we are going to discuss today is the module of governance gaps of monitoring of state obligations and enforcement. What will you learn from today's discussion? You would get an overall perspective on the different kinds of challenges that implementation of international humanitarian law faces, judicial or otherwise. You would also be able to demonstrate by the end of this discussion the understanding of problems of governance as well as lack of enforcement agencies to implement IHL norms and laws thereof. I'm sure you would be in a better position to articulate and analyze IHL enforcement mechanisms after this briefing. One of the most difficult tasks an international institution faces is to ensure peace, preventing conflicts which could lead to war and help in restoring war-torn nations. Conflicts can lead to widespread destruction in all the aspects of society, ranging from human rights to basic amenities like health and environment. Main factors for causing such uncertainty are terrorism, drug trafficking, slave girls, illegal arms, trade and environment exploitation, and so on. The foremost task for any international institution is to ensure that the state is willing to work in compliance in order to mitigate these issues. The problem arises when there is a lack of political consensus, financial source, and lack of enforcement mechanism, and it is necessary for smooth functioning of the international institutions to deal with such issues first. To ensure that war crimes abomination are not repeated, the Geneva Convention presented a system of appointing protecting powers to safeguard the interests of the protected persons and make sure that they are treated in accordance with the rules set forth by these conventions. However, this system has been unable to be implemented to its full force. But there are certain provisions which ensure that the person is held accountable for its actions. States have an obligation to its citizens to carry out the necessary research or investigation into the accused who is accused of carrying out serious crimes or inhuman breaches, which can vary from killing of people to biological treatments to serious bodily injury, and making sure that such people are held liable for punishments. Although the states have included in their penal codes certain provisions with respect to war crime atrocities, there is lack of enforcement of such provisions. The states lack a mechanism, a system, which is necessary to prevent such catastrophe. Moreover, when cases pertaining to these matters arise, a major confusion with respect to who handles such cases also arises. At such a point, issue of hegemony arises, where states are unwilling to take up their respective obligations and responsibilities because of geo-strategic, political or other interests. Due to this, the international institutions are unable to fulfill their respective promises. What about global governance then? The word governance has always been linked with the idea of institutions, isn't it? Political parties or all systems which represent control is another aspect which we associate with governance. Governance in this sense denotes formal political institutions that both aim to coordinate and control interdependent social relations and that also possess the capacity to enforce decisions. Despite the fact that United Nations has failed at various instances, it is still the most universally accepted and legitimate institution which has the greatest potential to achieve good and effective global governance. Global governance cannot be restricted to just who has policy over what region, but an understanding between actors taking part at local, national, regional and global level is a requirement too. At this point, 5 global governance issues have been put forward by the United Nations between the present global disputes and limited solutions present for these disputes. These gaps revolve around knowledge, norms, policies, institutions, and compliance. Let us discuss them one by one. Knowledge gap is the first kind of governance gap. Generally, it is observed that it is irrelevant whether there are institutions or no. There is consensus or no with regards to the nature, cause, gravity, and magnitude of a problem. However, what is constant is the disagreement over the most useful solution which is presented for the problem. One example about this is that of global warming or about the restriction of the use of nuclear weapons. Even making an effort to fill the knowledge gap partially can help in dealing with other gaps that exist in the sphere of global governance. Till date, United Nations has been successful in filling these knowledge gaps. Many a times there are certain ideologies which are followed by the state, due to which empirical data may not be sufficient enough to change their minds. In such a case, the role of the state in the development process and at the same time controlling market forces is a major phenomenon. What about the second kind of governance gap, which is the normative gap? The word norm has various meanings, with all pointing to the same conclusion. A norm may be defined as a behavioral pattern that is most widely accepted or seen. In other words, it is a behavioral pattern that is followed according to a society, belief system, or otherwise any other faith system. Norms play a major role in governance gaps mainly because it is human nature is such that one cares about what the other thinks of them. United Nations provides the state with a platform to codify the norms in the form of resolutions and declarations. However, one may witness the powerful states may dissent to the resolution, which leads to no common solution, or such a solution which is not beneficial to anyone concerned, or just a few of them concerned which happen to be hegemonic. And that would lead to a normative gap. Third governance gap is of the policy gap. According to Oxford Dictionary, the word policy refers to a course or principle of action adopted or proposed by an organization or individual. Basically, policy is a set of mixed governing rules and goals along with possible solutions to put in place those rules and achieve the goals. At this point, United Nations acts like a forum where every state sends a representative to help in developing certain policy decisions while keeping in mind their state policies. Instruction and all the issues with respect to policy which their state's government seem to be facing is something which the state's representative advocates for and pushes for. However, while the source and the scale of most of today's pressing challenges are global, any effective solution to them must also be global. The policy authority for tackling those remains vested within the states themselves. The implementation of most UN policies, as determined by the first UN declaration, does not rest primarily with the United Nations Secretariat itself, but is kicked back upwards to member states. The fourth kind of governance gap refers to the institutional gap. Institutions are generally classified as formal organizations, but they do have informal establishment too. All the policy decisions require an institution for a smooth, free process of passing the policy, otherwise it can create havoc. There are international institutions that deal reasonably well with a problem area, and those that are most effective often deal with specific issues have well embedded norms and consensus among member states. Can you think of any examples of international institutions and organizations which would fall in this category? UNICEF in the case of child welfare, WHO in the case of global health and making a difference to the policy of global health. The best example is the World Trade Organization. Institutional gap is independent of other gaps, which is even if other gaps aren't in existence, institutional gap will often exist. Only the scale and the extent may vary. Reasons for this could be that not many states are party to an institution. Thus, in conclusion, it can be said that the problem for institutional governance arises due to lack of resources to cover the entire problem. The fifth and the final governance gap now brings us to the most common problem faced by an international institution while implementing or trying to think about global governance. It is compliance gap. Compliance facts has three major elements which need to be fulfilled. These are implementation, constant supervision, and enforcement. Various instances, many states, although agree to a particular policy, they fail to implement it in their legal systems. Therefore, even if a treaty is in existence pertaining to a common problem, it will have no effect if there is no political will to implement the treaty. At such times, the question which may arise is, who has the authority, responsibility and capacity to monitor and influence and implement the commitments made and obligations accepted as being honorable commitments by the states? Various instances are there where United Nations itself has tried to come up with solutions to deal with such issues. The common one being embarrassment, which happens when the United Nations secretariats prepare a report about non-compliance of any particular state. Unfortunately, in the context of human rights, there has hardly been an enforcement mechanism which has been put forward, whether it be soft law or hard law. Although International Criminal Court statute provides for such a regime, and ICC was set up with such a view, and some convictions have taken place when the cases have been of war crimes, atrocities, and the result is very much limited. Reparations would raise another important question that we should talk about. And which reparations? Reparations for violation of international humanitarian law. It is the obligation of the state to provide those who have faced international humanitarian law violations with remedies. However, this hasn't been such an easy task, as the question keeps on arising as to who comes under the right and whether such rights can be granted to individuals. In spite of the gap in the international law, Commission's articles on state responsibility, which were finally adopted in 2011 but failed to mention rights of individuals in the regime of secondary rights. It is generally known that human rights treaties provide a remedy, both substantive and procedural, for individuals suffering injury from unlawful conduct by state authorities. Thus, despite the fact that various laws have been put in steps to protect interests of the individuals, the reality is that the individuals are still being taken for granted, taken for a ride by the government, especially in the instances of armed conflicts. As mentioned above, various steps have been taken by setting up ad hoc tribunals and International Criminal Court, but it isn't enough to achieve a universalized consensus-based system of global governance. The word reparation has been defined by the International Center for Trans Justice as reparations seek to recognize and address the harms suffered by victims of systematic human rights violations. One of the most basic principles of public international law makes it clear that any wrongful act gives rise to an obligation to make reparations, be it any violation of any obligation under public international law. The main purpose of reparation is to go to undo situation and place the situation as it was in place before any illegal act took place. There are various forms of reparations which involve restitution, compensation, or satisfaction. There may obviously be circumstances in which restitution is materially impossible. For example, if the property in question has been destroyed, there's no restitution which is possible as a remedy. It is necessary to keep in mind that this same principle is applicable in case of any violation of international humanitarian law. Although Article 91 of Additional Protocol 1 makes it clear that compensation is main criteria for any violation of international humanitarian law, however, an obligation to make reparation arises automatically as a consequence of the unlawful act. Without the need for the obligation to be spelled out in conventions, this unlawful act and its consequence would still be the determining factor. Let's now talk about the right to individual reparations after we've discussed the legal regime surrounding reparations as such. The above principle talks about one state making reparation to other. However, the question which arises here is whether the state is only entitled to reparations. If yes, then what about the individual victims? Initially, the peace treaties used to take the stand that the compensation which the state will receive will be sufficient enough to cover the losses of state and at the same time the sufficient for the individual victims of the state. International humanitarian law instruments are silent as to who are the beneficiaries of reparation under its agreements for violations of international humanitarian law. Unfortunately, they only address the responsibility to compensate, despite the fact that due to recent strikes, individuals have become aware of the fact that individuals do have a right to reparation for violations of international law of which they are victims. Unfortunately, what hasn't been put forward is a proper system facilitating this, and this could be one of the examples of institutional gaps which are suffered in today's age by all sorts of platforms and people. The main reason for such confusion is due to the fact that individuals are as treated beneficiaries and must claim their rights via their state of nationality. Up till now, individuals didn't have the right to bring claims against states with respect to violation of international humanitarian law. However, special tribunals have been set up with the help of treaty in order to give individuals and corporations particular rights to claim damages against their governments. Talking about war victim now, status and rights of war victims. Due to setting up of these tribunals, the notion of the word victim was raised. Traditionally, victim is a person whose rights have been violated. However, under the concept of international humanitarian law, victims are defined as those who suffer because they are affected by an armed conflict. They are termed war victims. The main right of war victims is the right to protection. The main purpose of international humanitarian law is to protect the war victims. In a judgment, rather in a very, very crucial judgment of 29th November 2002, the Supreme Court decided that the rules of international humanitarian law do not protect persons against stresses and tensions that are consequences of airstrikes as such, and do not protect persons with regard to whom the rules and norms have not been violated in concreto. The right to invoke the rules of international humanitarian law is therefore confined to those who personally were the victims of violations of international humanitarian law. Since there is a classification with respect to a victim, the remedy and reparation lies on which a right has been violated under international humanitarian law. In such cases, the primary issue is here to determine which right has been violated in order to determine the extent of reparation. But the problem arises when the compensation has been given to the state to transfer to the victims. No statute imposes any duty on the states to give effect to the provision of international humanitarian law. Thus, victims of violations of IHL hardly have any mechanism left with themselves to exercise their right under their national law. Unfortunately, the same is the case at international level as well. There is no binding principle which allows the victims to be able to contend those rights. In practice, all existing procedures under IHL are subject to the agreement of the parties to the conflict concerned, and none provide individual victims with the general right to a remedy for violations of the law. In order to sum up the discussion we've had so far, one might say that there are very few avenues available for a war victim to get compensation for the harm caused to him or her by alleged international humanitarian law violations. There are very few scenarios where victims are given the right of their own to a remedy for violations of international humanitarian law, either at national level or at international level. After the Second World War, in the Shimura case, the plaintiff happened to be one of the survivors of the atomic bombs in Hiroshima and Nagasaki. The plaintiff claimed that since Japan has signed the 1951 peace treaty with the US, Japanese government was entitled to pay the compensation as they had wrongfully waved it away. Now, although atomic bombing constitutes as a violation of IHL, the court took the argument presented by the Japanese government, which was that the individual had no right to remedy under international law as per Article 3 of Hague Convention 4, and ruled in the favor of the Japanese government. This goes on to show the number of cases where compensation is not awarded is more in number than those in which compensation has been awarded. I hope this discussion has introduced you to the fallacies and flaws which are there in the implementation for claiming compensation by individuals and corporations against the violations of international humanitarian law. Thank you.